CPL Test 5, Part 2, number 17. This might be a repeat. If a court fails to rule on request to charge, so a request to instruct the jury, such failure is deemed a denial of the request. 18. Select the correct statement concerning a recess of jury's deliberation. A is wrong. They can always declare a recess. B, the court must allow the parties an opportunity to be heard outside of the jury's presence, and this is wrong because it's before declaring the recess. C, except for Saturday, Sunday, and legal holidays, the recess may not exceed, and this is wrong because it's 24 hours. And the correct answer was D. The court must direct the jurors not to recommence deliberations until all 12 are reassembled in the designated place at the termination of the declared recess. 19. Which, if any, are true concerning deliberating juries taking of exhibits into the jury room? And the answer here is 1 and 4, but not 2 or 3, so D. The court must allow the parties an opportunity to be heard prior to the giving of exhibits. That's true. And the court has discretion in deciding what exhibits to give the jury. So maybe we're not going to give the jury the gun. The jury does not have to request the exhibits, and the parties do not have to consent. Now, the reason I put these in here is because I do not want you to mix up the taking of exhibits to bringing a copy of a statute. So a copy of a statute would be like, what is the definition of penal law 125 or something? And if the jury requests that or further instructions and the court gets consent to the parties, the court can allow a copy of the statute to go into the jury room with the jurors. But that's not the same thing as what this question is asking. This question is asking about exhibits. And for exhibits, it's opportunity to be heard in advance, and court has discretion. So number 20, we are skipping. 21, who must be present when the court gives a deliberating jury further instructions on the law? And the answer is A, one only, the defendant only. The way the statute reads is that with proper notice to the parties and in the presence of the defendant, the court can give further instructions. And then it goes into the thing about with consent, the court can give a copy of the statute. 22, in general, confinement in a secure facility pursuant to an examination order shall be for 30 days. So examination order equals 30 days. And when we see examination order, what do we know? We know we are talking about mental disease or defect. 23, if court finds defendant whom a jury has found not responsible by reason of mental disease or defect has a dangerous mental disorder, it must issue a commitment order. Commitment order. Okay? So dangerous mental disorder, you have to think commitment order, 6 months, secure facility. Those three things go together. Examination order, 30 days. Commitment order, 6 months. 24, which, if any, of the following concerning a motion to set aside a verdict? 1 is wrong because it's made by defendant only. 2, may be granted on any ground which, if raised on appeal, would require a reversal or modification by an appellate court. That's true. 3, ground includes new evidence has been discovered since the trial which could not have been produced by defendant at the trial, even with due diligence on his part, and which is of such character as to create a probability that had such evidence been received at trial, the verdict would have been more favorable to the defendant. 25. Upon a verdict of complete acquittal, the court must immediately discharge defendant if he's in the sheriff's custody, or if he's at liberty on bail, it must exonerate the bail. So answer was A, immediate. 26, if commissioner decides to seek a furlough order, he must give 10 days notice. 10 days notice. So furlough order, we have 2 time periods. We have 10 days notice, and the furlough order itself can be up to 14 days. 27, notice of commissioner's decision to seek a furlough order must be given to DA, defendant, defense counsel, and mental hygiene legal service. So A, it's all of them. 28, an examination order. So remember, examination order, 30 days, means an order directed to the commissioner requiring that a defendant submit to a psychiatric examination to determine whether or not the defendant either, one, has dangerous mental disorder or is mentally ill. So the answer is D. So those are the two things the examination order is looking for. Two psychiatric examiners are looking, do we have a defendant with a dangerous mental disorder or he's mentally ill? 29, a judicial hearing officer, also known as a JHO, may conduct a non-jury trial of an information charging defendant with a misdemeanor unless the information charges defendant with a Class A misdemeanor. Okay, so answer D. 30, Mary is a 17-year-old eligible youth within the meaning of the YO procedure and has never been convicted of a crime or adjudicated a youthful offender. She is about to be tried on an information charging her with a Class A misdemeanor. Her trial must be a single judge trial, and that is true. Now, I cannot explain it. The maximum sentence is 6 months, so for some reason, she loses her right to a jury trial, even though we're not in New York City. I'm not sure why, but just know, mandatory eligible youth, never been convicted of a crime or adjudicated a YO, and she's only charged with a misdemeanor. She's got to be a single judge trial, and I don't know why. Okay, 31 I accidentally skipped, so I'm going to do it now. It says, it's a true or false, and says something like, a defendant doesn't testify on his own behalf, the court has to give a jury instruction telling the jury you cannot draw any unfavorable inference from the fact that he didn't testify. It is false, because the only time that the court is permitted to give that instruction is upon request of a defendant who didn't testify on his own behalf. And the law actually goes out of the way to say that upon request of the defendant, but not otherwise, the court would give this instruction. Just know that it's only upon request, and if the defendant does request it, the court has to give it. And it's like basically saying you cannot draw any unfavorable inference. You cannot draw an unfavorable inference from the fact that the defendant did not testify. You cannot draw an unfavorable inference from that. 32. After rendering the verdict, the foreperson must be asked whether the jury has agreed upon a verdict and must answer in the affirmative. And that is false because it's before the verdict is announced. Number 33, we're skipping. 34, where a single judge trial of an information in a local criminal court is conducted by a JHO, which of the following statements are true? And this one, we have both the defendant and the people must agree that the case be tried by a JHO or judicial hearing officer. It's true, you have to get both of them to agree. The JHO is the trier of fact and determines all questions of law, so we know 2 and 3 are true. And 4 is false, because the JHO must render a verdict. So the answer was C, everything except 4. 35, which are true concerning a jury's request for a list of witnesses that testified during the trial. And the list is prepared by the court. So 1 is correct. And the list has to be all of the witnesses, so that's wrong. It cannot be prepared by DA defense counsel, that's wrong. And the court may refuse to provide the jury with a witness list. So that sounds a little weird, number 35, but that's true. The court can refuse. 36, upon entry of a verdict of not responsible or acceptance of a plea by not responsible of reason of mental disease or defects, the court must immediately issue an examination order. So 30 days examination order, upon the verdict or plea of not responsible, examination order 30 days. 37, upon receipt of the order designated in question 36, the commissioner must designate 2 qualified psychiatric examiners, and the court may authorize a psychologist or a psychiatrist retained by a defendant to be present at the examination. The clerk of the court must promptly forward a copy of the examination order to the Mental Hygiene Legal Service. Now, Mental Hygiene Legal Service is like legal aid for mentally ill people. 38. The court must specifically designate and submit those counts and offenses contained and charged in the indictment which the jury is to consider. Such determination must be made and the parties informed thereof prior to submissions, so that the jury is not having their time wasted with lawyers arguing about counts that aren't going to be even be submitted. It's got to be prior to summations. 39. If the jury renders a verdict which is not in accordance with the court's instructions, so the bad form, the court may, and then the court is allowed to do a couple of things, but basically for the purpose of this question, the answer was none of the above. We're going to go over 310.50 sub 2 in the statute so that you see this the way it's read in the book. 310.50 Verdict Form Reconsideration of Defective Verdict. 1. The form of the verdict must be in accordance with the court's instruction as prescribed in Article 300. If the jury renders a verdict which is not in form with the court's instructions or is otherwise legally defective, the court must explain the defect or error to the jurors, tell them to get their asses back in the jury room, reconsider the verdict, resume their deliberations for that purpose, and render a proper verdict. If the jury persists in rendering an improper verdict, the court may record the verdict as a complete acquittal as to any defendant, or discharge the jury and authorize the people to retry the case, or it may accept a verdict as a partial verdict. However, if the court authorizes the people to retry the indictment in front of some other jury, and it was clear that the jury intended to find the defendant or another defendant not guilty of a particular count, that has to be recorded as an acquittal. Next, if the court accepts a verdict that is defective based on the fact that the jury did not find the defendant guilty or not guilty on all of the counts, and the court accepts that verdict, so let's say there's a 20 count indictment and the jury only filled in the boxes for 15 of the counts, those other 5 counts must be recorded as an acquittal if the court accepts that defective verdict. 40. A peremptory challenge is an objection to a prospective juror for which no reason need be assigned. So no reason. 41. True or false? In its charge, the court must, among other things, state the legal principles applicable to the particular case, and so far as practicable, explain application of the facts, but it need not marshal the evidence or refer to the evidence to any greater extent than is necessary for such explanation. That is true. Number 41, that is true. So make sure that you memorize that and understand it. Number 42. If the court is authorized to submit a lesser included and either a party requests to do so, it must do so. 43. The jury verdict must be announced by the foreperson in the courtroom, and if the foreperson refuses to, then the court will designate someone else to do it. Maybe he's shy, as Angela said. 44. When a defendant is a J.O. who does not stand convicted of murder second degree upon motion and with consent of DA, the action may be removed to family court in the interest of justice. 45. The court must deliver a charge to the jury at the conclusions of summations. So when must the court deliver the charge to the jury? And the answer is after conclusion of summations. Again, play that movie in your head of how everything goes. Defendant closes, people close, court's charge. 46. A non-jury trial of an indictment must be conducted by a superior court judge, by a single judge of the superior court in which the indictment is pending. So it's one judge. So single judge, one judge in the superior court. 47, which are true concerning a JHO. He cannot try Class A misdemeanor. Rules of evidence shall be applicable to a regular non-jury trial, and the court may, upon agreement of the parties, assign a JHO to try a case. and it may only be authorized where a single judge trial of an information in a local criminal court is requested. So they just remember they both have to consent, no Class A misdemeanors, and where it's authorized, not requested. So the answer to 47 was B, 2, 3, and 4, but not 1. 47. Basically, you just have to know about what is the JHO. It's the same rules of evidence as in a regular trial. They cannot get a Class A misdemeanor. The parties have to agree. The court may assign a JHO to try an appropriate case, and it's only authorized where a single judge trial on an information in a local criminal court is authorized. It's not requested, it's authorized. 48, if an indictment contains 2 inconsistent counts, the court may not submit both of them, but must submit one of them. That is false. If there's 2 inconsistent counts, the court can submit both of them. Which, if any, are true. Court may only give the jury copies of text of a statute if the jury requests it, the parties consent, and in its discretion, the court deems proper. And that is the answer. Okay? Compare this to the exhibit thing. When defendant is a juvenile offender or an adolescent offender who does not stand convicted of murder in the second degree, upon motion and with consent of the DA, the action may be removed to family court in the interest of justice. 51. For which courts may an administrative judge assign traffic infractions to JHO without consent of the parties? And the answer is Nassau, Suffolk, and Buffalo City Court, not New York City Criminal Court. That's relatively new, the Buffalo City Court thing. But basically that's why they have a Traffic and Parking Violations Bureau in those counties.